constitutional provision of Article 158. What does the law say? Once charged, because you have filed a petition, the person that has been charged needs to step aside. The judgment of Justice Mumbi Ngugi that the DPP has always fought to implement is that once an allegation has been made by the governors, they cannot step in their offices. We are urging the DPP, and that is what we are saying, the Public Service Commission must tell the DPP to step aside. The witnesses in the cases that we have filed are his employees. They cannot come to testify against him because he'll intimidate them, the way he claims governors and other public officers intimidate their juniors. In Njeru's petition that Mr. Cliff has raised, there are other grounds that we have raised. The first ground is the ground of the late Tekla. Tekla was alleged to have been murdered in Lamu. The DPP, after the DCI provided for evidence to charge, the DPP approved the charge sheet. The charge sheet was taken to the High Court in Garsen. Immediately, the file was going to be called. Before the file was called, a DPP entered a nolle prosequi. A nolle prosequi under the old constitutional dispensation was a document that once the DPP files it, the court has nothing to move forward. Under the new constitution, you cannot terminate a matter that is already filed before you give reasons to the court. The DPP went ahead and entered a nolle prosequi even before the suspect had been charged. History in the making by the Director of Public Prosecution. Two, when the decision not to charge was done and he referred the matter for an inquest, the DPP preferred the inquest to be in Lamu. The family wanted the inquest to be in Nairobi. A legal battle ensued in court. The court overruled the DPP that the inquest will be done in Nairobi. What special interest does the DPP have in that matter? That he goes ahead and enters nolle prosequi and enters his matter, Njeru's matter, because of nepotism. Third, within the petition, we have raised the question, NYS suspects, banks were involved in transaction of the money. The banks pleaded guilty. The DPP decides he will go himself alone and negotiate with the banks. The DPP arrogates himself the power of a judicial officer and fines the banks. The DPP has only prosecutorial powers. He does not have the judicial power to fine. He fined the banks. How much the banks were fined is only known by one Noordin Haji. It is not in the public domain. How much did the banks got fined? Although the fining was illegal, free. He went ahead and opened an account in a commercial bank in one of the banks that were fined. The laws of this country, it is only the treasury that can open an account for money for the public. The DPP is running a private bank account. We don't know how much money is there. The DPP moves ahead during COVID pandemic, removes 2 billion and hands over Kenyans' money without consulting and asking the Kenyans. He donates to the COVID billionaires. Remember, to date, KEMSA suspects, the billionaire of KEMSA, have never been charged. The questions in Njeru's petition are: one, who authorized the DPP to open an account outside the consolidated fund? Who gave him the jurisdiction and the mandate to fine the banks? Three, how much money is in those banks? Fourth, when did he become the Treasury to open an account. Remember, in the petition we filed of Top Cohen, we raised the question that the DPP has amalgamated all cases that have huge amounts of money to himself as a person. When did the asset recovery, an authority created by government, an authority funded by government, cease from doing the mandate it is supposed to be done, and the DPP takes it? As Cliff says it, the DPP is rogue. He's the law himself. He can decide who he fines. He can decide where he takes the money. And lastly, in that issue, he purported to enter into secret agreements with the banks, very confidential, only known to him. How can that office run under the leadership and stewardship of one Noordin Haji? Lastly, on that issue, we are demanding from the public, from Treasury, that we get those details, and he has gone ahead and deferred. In the petition we have filed, he has deferred plea taking of the bank's managers. If the DPP can negotiate and defer plea taking of banks that are swindling Kenyans, what about ordinary citizens? Can the DPP defer a plea taking of a person who has stolen chicken? The law should apply equally. The DPP is a DPP for the super rich and the politically connected. Kenyans of lower ranks, who are almost 50 million, excluding the 2,000 the DPP is protected, are alone. And that is why the likes of Njeru comes on record to fight for this, to expose whatever issues that are there. You have seen the report that we have given here. This book is a study of the perceptions of and experiences of corruption in the Republic of Kenya. It is a book that was done, a study that was conducted by all government agencies, and it has been signed none other than the Attorney General of this country. It was launched by the Minister for Interior, Dr. Fred Matiang'i. And in this book, after research has been done, they have come to the conclusion that, on the other hand, most of the public officials thought that the state organs had achieved some marginal level of success, and hence rated the organs as majorly successful to a small extent, with the least performing organ being the EACC, followed by the Judiciary, Anti-Corruption Court, and the DPP. This is a report inducting the DPP that he is the most least performing entity in the fight against corruption. Why do we need such a man in office? What will it cost this country if the DPP still retains his position as the DPP? My good friend Shadrach will put one word before Martina puts another.
Thank you. Now, Mr. Njeru, please stand with me. Now, Mr. Njeru's petition and the myriad examples that my seniors have put to you is just but an example of the riot. It's a revelation of the riot and the decay that is in the ODPP's office, is an indication of the misdeeds that the ODPP has thus far done, that continue to step on the rights of innocent victims like Mr. Njeru and others that my seniors have mentioned. So in summary, what we have seen so far is an officer, a public officer, who is driven by his instincts of nepotism. A man who is protective of his cronies and family members, as Mr. Njeru puts it, so that these people are not available for prosecution when they offend the law. Mr. Njeru is a man who has worked so hard to buy his own piece of land. And now he cannot enjoy it because there are people who forge documents and who the court, through Honorable Eboso, ordered the investigation, and subsequently the DCI directed that these people should be charged before a competent court of law. But what happened really, as Mr. Cliff Ombeta, my senior, has put it, is that the DPP goes ahead to withdraw the cases against these particular individuals and prefer that Mr. Njeru should now take plea for his farm or his land having been stolen from him. So one cannot really understand why we will have the hunter now becoming the hunted. A person who is a victim of the crime now becoming the accused of his own, of his own wealth or property. So really, in summary, the petitions that are lying before the Public Service Commission is a calling for the Public Service Commission to do that which is right, to order that proceedings are conducted expeditiously, and that are proceedings that will lead ultimately to the removal of the DPP from office. We cannot allow criminals to be loitering in our streets, all in the name of them getting protection from the DPP. What is in order is that victims should have a safe haven. This country should be enjoying its personal freedoms and liberties, with criminals of offenses or criminals or perpetrators of offenses being locked up where they belong. Mr. Njeru, we are hoping that in the fullness of time that the Public Service Commission shall agree with your petition and we shall do the needful. Asanteni sana. Thank you.
You see, in this petition that we have filed before the Public Service Commission, it touches on matters of great interest of justice. It's a public interest matter, and as we have seen, not only did the family of Top Cohen complain about the injustices by the Director of Public Prosecution, but also ordinary citizens, ordinary Kenyans are coming forth with the injustices that have been occasioned to them by one Mr. Noordin Haji. The office of the Director of Public Prosecution should be protected. It is an office, and it actually has advocates of the High Court of Kenya as prosecutors. And we are also protecting our profession because it's shedding us in a bad light. We are only praying that the injustices that are in that office be removed. If Mr. Noordin Haji is the person who is interfering with the sanctity of that office, then it is only a matter of time before he is removed from that office. Therefore, the petition he has filed before the Public Service Commission is raising issues on nepotism, favorism, and injustices occasioned by him just because he has no status and because he's an ordinary citizen of Kenya who is not related to that Mr. Noordin Haji. And therefore, we are only hoping that the two petitions we have filed before the Public Service